Good afternoon, everyone, and welcome. This is part of a series of webinars that I hold with Justin Antonipillai of WireWheel. And today's topic is Web3 and blockchain and the implications of blockchain for the future and how blockchain fits into privacy law of today. And some of the issues that it raises. So I'd like to kick things over to Justin, who will introduce our great guest today, Colin.
Colin is one of the leading voices in Europe on these issues around privacy and blockchain. Colin is a partner in the technologies group at Arthur Cox. You wrote some of the early papers on some of the implications of a public ledger or a blockchain and distributed data when it comes to global privacy laws like GDPR, Colin. And because Web3, as Dan was mentioning it, has really become an area that's, if you read the general press, has become an area of great interest. And because Web3 fundamentally, as most people look at it, is based on recording data to either a public ledger like a blockchain, or there are now technologies that enable you to encrypt certain data as you're recording it, to effectively pseudonymize data as you're recording it to a blockchain. We thought this would be a perfect moment to have you on. So first of all, welcome, and I'm sorry about the technical glitch there, Colin. Thank you for joining us.
Not at all, Justin, and thank you. And as I said, I might just, before dealing with, I think, the clash between GDPR and blockchain and distributed ledgers in particular, I might just take a moment just to explain what we're talking about. So when we talk about a blockchain, we're really talking about blocks of data linked together in a secure fashion, and usually through hashing technology. Each block of data effectively has a part of the previous block. So what you end up is effectively a secure, continuous, and immutable chain of blocks, and that's sort of the underlying technology. Now, just bear in mind, in terms of what I'm going to say about the GDPR, the key piece here is the immutable, or the key challenge is the immutability of the blockchain. It's the selling point from the technology's perspective, but it's also the challenge from the GDPR side. So the very thing that's giving trust, reliability, and bringing integrity to blockchain networks is really the thing that's causing the problem from the GDPR, and let's be frank, other privacy law perspectives as well. When we talk about blockchain, we often talk about distributed ledgers as well, and effectively what we mean are databases which are stored in a decentralized fashion across various different nodes and across various different locations, but which are synced by consensus effectively, such that they are one unified database. So we're talking about relatively sophisticated technology, relatively cutting edge technology, which has a variety of applications, and we'll talk about that. That's very early stages, it seems to me. But before we get to the applications, we have to consider how this sits with the current regulatory regime. And there's been...
Well, do you mind, Colin, if I kind of take that piecemeal? Because there's a lot you covered even in that brief little introduction, right?
Yes.
So let's start with some basics. So first of all, you're talking about recording pieces and transactions to a blockchain. And as you said, you're recording them in a way that makes them fundamentally immutable. And they're immutable in part because you've recorded each block, and there's sort of another block that follows, which means it becomes very difficult to create a fraud around what's recorded on the blockchain. And that ledger, as you mentioned, is also distributed to multiple nodes. So in part, the security and immutability of a blockchain is ensured by the fact that the blockchain is replicated, and then which transactions are valid is determined by consensus of the group of folks essentially running the nodes of the blockchain. Okay, now let's just go through some of the questions that have come up about because, there's a lot of different things you can build on top of a blockchain, right? So, for example, Bitcoin is a currency built on a blockchain. That's an example. But there's other things and other applications that you can build on top of a blockchain, including some of the Web3 components. But they fundamentally have this character of the recording on a ledger is supposed to be immutable. The recording on a ledger is public. So as opposed to a bank ledger where only the bank knows about the transaction, every transaction recorded on a blockchain is public by nature, number one. And number two, you're actually distributing those recorded transactions across multiple nodes, and those nodes might be in any geography, right? So almost by definition, when you start recording to a well-used blockchain, you're probably taking personal data and spreading it across multiple geographies quickly. So when I saw your article, it was interesting. You sort of identified some of the interesting tensions with a law like GDPR. An example of that is assuming that I record a transaction that's tied to a wallet, like a Coinbase wallet, and my wallet is recorded on a blockchain. Once it's recorded on that public blockchain, you can't unrecord it. So there's a tension with GDPR concepts like, is a transaction recorded on a blockchain personal data? If it is personal data, how do you think about fundamental rights like the right to be forgotten on a public blockchain? And then in a moment, if you don't mind starting with those, then I think we can get to some of the harder ones like international data transfer. But
yeah,
do you mind starting there, Colin?
Yeah, no, that's a very good place to start, Justin. I mean, I think let's start from the position that it is highly likely that the information which is being stored on the blockchain will be considered to be personal data. The definition or the meaning of personal data within the EU has been for the last decade or so been undergoing a process whereby it's becoming broader and broader, and more information is being considered to be personal data in a way that perhaps would be surprising to those who are not necessarily at the coalface of data protection. And that goes as far as parts of the GDPR. I would refer the audience to recital 26 of the GDPR if you want to have a look and see what the kind of thinking is on the part of the EU around what the meaning of personal data is. And there's also a very important decision some years back, not actually based upon the GDPR, based upon the preceding legislation, the 95 directive called Breyer, which was a decision of the Court of Justice of the European Union. And that talks about things like dynamic IP addresses. So IP addresses which can change frequently being considered to be personal data in certain circumstances. So you're absolutely correct to say you have a public database which is likely to be holding personal data. And because it's likely to be holding personal data, straight away you have an application of the GDPR. Now, there have been a lot of considerations, and there's some solutions which we can talk about a little bit later on, but there's been a lot of consideration given to whether or not you can potentially anonymize the data and whether that would render the GDPR non-applicable. Because if you can truly anonymize data, you're in a situation where you can't make the argument that the GDPR doesn't apply. The challenge there is, again, the case law and the push of regulatory guidance has in general been to say that anonymization must be to a very, very high standard. Some of the guidance which has come out from what's called the Article 29 Working Party and effectively the European Data Protection Board has talked about really being, there being very, very, very low risk of re-identification of an individual if your anonymization is truly effective. So what you end up then is a situation where it can be very, very challenging to make an argument, to make a successful argument that there isn't personal data on the blockchain. Now, I should say, not all regulators are singing from the same hymn sheet here. And the ICO, the UK's regulator, has adopted a slightly broader position in terms of what it would accept as being anonymization, which is interesting. It's interesting in the context of Brexit. It's interesting in terms of the freedom the ICO has. And it's just interesting in terms of some of the flexibility that's being shown by some of the regulators, which I think is going to be necessary if we are going to find ourselves in a situation where blockchain is, and distributed ledger technology is ultimately going to be somehow reconcilable with the GDPR, whether it's the EU or the UK GDPR. In terms then of the clash with data subject rights and related issues coming off the fact that you have this storage of data in an immutable fashion spread across multiple locations, likely outside of the EU, you've got all kinds of difficulties. The GDPR, as the audience will be aware, works on the assumption that there is somewhat a simplistic assumption that there is a controller, there is a processor, in some cases there are joint controllers. So a very simple designation of actors or players in the processing framework. That's very, very difficult to transpose onto a distributed ledger where there are multiple players doing multiple things, sometimes just storing the data, sometimes providing an interface into the blockchain, sometimes providing some other sort of related service, and sometimes just developing a solution. And the role of those different parties is very difficult to designate, which creates an additional challenge. Over and above that, then, I think the key problem tends to be, how do you discharge data subject rights? So how do you discharge a right, like, as you mentioned, the right to be forgotten, or in its more, a technical term, the right of erasure? How do you do that in circumstances where the value, the integrity of the blockchain comes from the very fact that it cannot be changed, and that if it is changed, that sort of undermines the trust. And all of the related rights. Again, the right of rectification is very, very challenging in this context, because how, again, do you discharge those obligations, do you discharge those rights, when the very basis of the blockchain is that you shouldn't be able to make any changes? So I think
that's an important one. So, and Colin, if I may, I'll share with our viewers, you're actually participating on some working groups in Ireland that are actually looking at these issues, including, as I understand it, folks from different constituencies. And this gets complicated quickly, because when you're talking about blockchain, you're talking about not only a means and effectively a public database on which you can build a distributed app, but you're also sometimes talking about the underlying technology for a currency like Bitcoin. So there's multiple regulators looking at the same kind of issue. So, I mean, if I could, for everybody sort of watching, one strong supposition we have, Colin, talking about this is data recorded on a blockchain that we think about as normal transactional data, even if it's associated with a wallet as opposed to your personal information, is likely by at least some of the regulators in Europe to be viewed as personal information if you apply the same rationale that was applied to a dynamic IP address, that it's likely that somebody's going to conclude this is personal data. And once you get to that point, then it's a little difficult to see how you apply foursquare certain normal rights under GDPR, like the right to be forgotten, or the normal requirement of a controller processor, because a lot of the blockchain underlying infrastructure, there's no corporation there. It's governed by something else. And by the way, if you don't mind, I know you're probably familiar with the concept of a DAO. Do you mind talking a little bit about some of the governance mechanisms that you've seen applying to blockchain, if you're familiar with them, Colin? And have you all had a chance to look at that in terms of the controller processor issue?
So the governance mechanisms that I've seen have varied. The main things that I've seen suggested in terms of how to sort of manage the interaction with the GDPR have ranged from what I would describe as being the highly aspirational to what I think is the more pragmatic. So the highly aspirational is arguments that you would have private permissioned blockchains, that you would have effectively circumstances where you would only allow the blockchain to be available to certain individuals, that they would have to sign up to certain for want of a better description, governance mechanisms, and that would allow for there to be some control around the very issues that you've discussed. For example, designation of who's controller, designation of who is a processor or joint controller, designations around who's responsible for transparency, for fair processing notices, designations around how you're going to manage data transfers, and are you going to have standard contractual clause, or are you going to do something else? So that's been one mechanism which I've seen proposed. Another, which I think it does veer now, it's very much as I would see it into the aspirational space, is to make arguments that potentially you would try to keep personal data off the blockchain altogether. And that is effectively an argument that you might use some sort of interface software, some sort of middleware or something like that, to effectively make sure that what was stored on the blockchain wouldn't be considered to be personal data. I think that might be a solution for the future. It certainly seems to me to be a solution which may become more practical over time, but it is a solution which I think does merit some further consideration. The other thing that I've seen considered quite a lot is really around governance, right? So making sure that you have a kind of an appropriate contractual framework in place, such that those who are participating have effectively signed up and they kind of understand the rules. And first of all, there are rules, and there's a kind of a structure put around that. And I think the thinking in that regard is that you're really able to, in addition to it having a private permissioned blockchain, you're able to then address some of the GDPR requirements. And that does look like you're putting or seeking to put a centralized control or centralized mechanism on top of what is effectively decentralized technology. So that can be very, very challenging as well. So there's a couple of different things that I've seen done well. Some, are proposed in that space, Justin, to sort of address those kind of issues. Beyond that, there's some discussion around sort of, for example, advanced encryption, technologies, which again can be deployed. So on the more technical side, and again, the thinking is that while you may not be able to do a full deletion of the data, to meet the right of erasure or right of rectification, you can take steps to effectively put the data beyond use, which again is a concept which seems to have been, I wouldn't say adopted, but to a limited extent endorsed by the ICO in the UK. So there are some ways and means to think about how you deal with the issues, but we really are talking about situations where you're closing the network to a certain extent, if it's a permission-based network, or you were working on the basis that you're trying to keep certain types of data through technology or otherwise off the network. And I think that they are rather extreme responses to the challenges that you're going to face if you're using a blockchain technology.
So under the GDPR, who would you enforce against? So it could be that, a use of blockchain violates the GDPR, but who do you enforce against? And if there's no one to enforce against, it could violate the GDPR, but if there's nothing, there might be nothing that could be done if there's no one that they could go after or really, or is there? Because ultimately it could be that, it doesn't fit into the GDPR, but it might not be actually, there might not be any levers to, enforce the GDPR for blockchain, or are there?
Yeah, Dan, I think that's the $1 million question in many ways, right? What do you do in circumstances where you are a regulator and you are faced with a complaint? So, for example, if you're sitting in the Data Protection Commission's office in Ireland, and you're faced with a complaint in relation to how your data has been processed by a solution which is relying upon a distributed ledger technology, where do you start? And I think that's the key problem. Absent having some sort of contractual framework which the regulator can look to and then try and see if they can work out who has held themselves out as being a controller. They have no place to start. They have no place to begin, and they've no place to enforce against. Now, that might seem like a great solution if you're not the regulator, but the problem with that is that very, very quickly then the regulator comes to the conclusion that, well, if there's not a party that I can enforce against, and there is processing which is within the EU or directed at individuals who are in the EU, well, we have a major problem then, because there's certainly processing which, as a regulator, I have responsibility for, but it's very difficult for me to identify who I pursue or how I go about that. So that's not really a sustainable position. There's an excellent paper by the German Blockchain Association. That my German is not all that it should be, so I'll have a go at the pronunciation, but I think it's the Blockchain Bundesverband who talk a little bit about that issue around enforcement as well, and about the challenges there. That you would need for if your blockchain solution was going to be compliant with European data protection law, you would need to have identifiable controllers, to a lesser extent identifiable processors, and really you would need to have put some structure around the various different actors within that milieu, within that context. And that paper actually goes as far as trying to say, in the case of, for example, developers, what role might they play? In the case of nodes or controllers of nodes, what role would they play? And tries to actually designate those roles. I'm not saying they've got it entirely correct, but it does show that is that enforcement issue, which is a very, very big issue within Europe at the moment in terms of the nature of enforcement, the speed of enforcement, the levying of sanctions, etc. That if you have a technology which is maybe nascent at the moment, but which is promising some very significant developments, and there's not an ability to enforce against it, that is going to be a major challenge.
It's interesting that, if that's the case, then, one is the response is to try to build in a way to control it. Another one is if it doesn't happen, what could the regulators do? So, if there isn't a mechanism that is built in, and how would they find a way to assert their power if there is no way, or would it just be they don't like it, but it's something they can't touch? Or is there a way they could thwart it or otherwise interfere such that they would force a way for it to fit into the GDPR? Or if they can't, have the lever to force it, it can just go on and just be outside for all practical purposes, not be regulable.
Yeah, I think the way that tends to play out, Dan, from a European perspective, is there is sometimes processing which is undertaken which operates outside of the regulatory environment. I mean, that'll be the same in the US, it'll be the same in other environments, but that doesn't tend to continue on an indefinite basis. And I think you usually find that if there's a difficulty with, for example, the data protection regulator or regulators across Europe taking action, there is usually another regulator in another context who can act in that regard. So sometimes if it's financial services, or there's a financial services element to the particular solution which is being offered, you will see the financial services regulator take an issue. And increasingly, we'll all have seen this in circumstances where there's a data element, but there's some impact on the market. We see the competition regulators becoming more involved. So I think what you tend to find in those type of situations, at least in my experience in the European side, is joined up action by regulators in circumstances where one finds it's unable to act. You might find that there are other channels, whether it is competition, whether it is sometimes taxation can be an issue as well. The other thing that I think sometimes you find here is that where the regulator can't act, you will find that individual data subjects take actions themselves, and they've been quite, that's been quite common in Europe. Again, we've had big changes, for example, or we have got fairly major reforms coming within Ireland and across a lot of Europe in relation to data retention. And that hasn't necessarily been spurred by individual regulatory action. That's been spurred by private actions by individuals through the court system. So I think that you're still left with the major problem here, which is, in very simple, old-fashioned to a certain extent legal terms, who's my mark? Who am I pursuing, and how do I pursue that party? I think what can happen is, in circumstances where you have one element of the processing, whether it's happens to be a node that's based in the EU, or you have one of the players to a certain extent housed in the EU and having jurisdiction, will they become effectively the mark? Which I think is another problem with this, with the approach here, is that you may find that you're pursuing a party because it's convenient from a jurisdictional perspective to go after them, rather than because they are the party who should necessarily bear the responsibility. And the other thing as well, I think, to say in terms of decentralized technologies like this is that, maybe we do need, we need the regulators as well to give some thought to moving away from the idea that there is one controller or maybe two controllers who bear sole liability for the processing. I mean, the very fact that it is decentralized and the very fact that there is a multiplicity of players may mean that it is a situation where it is a complex enforcement issue, and it would require enforcement against a large number of entities.
Colin, so I mean, again, that's this underlying sort of, we've spent maybe the last 30 minutes talking about blockchain and some fundamental sort of tensions, and I think Dan highlighted one. I'll do one last one, and then I'd say we move over to Web3 for the last 10 minutes or so of our discussion, because in some ways, Web3, you're not talking about companies or a controller or somebody who's building an actual application that runs on a blockchain, right? So some of these are distributed apps that are actually built by a company, right? And there you start losing the problem of a controller. It may not cure some of the underlying problems, but it does at least give you a target that the regulator can look at. But one last one I wanted to just cover is, how have you and these working groups thought about the concept of international data transfer when you're talking about a blockchain that's distributed? Like, how do the regulators think about that issue right now in Europe?
I don't know how the regulators think about that issue right now in Europe, because, and I don't mean this in any way to be disparaging, because I think they're struggling at the moment to figure exactly how to manage the issue outside of distributed technologies, frankly. We have had Schrems 2, obviously, that decision. We've had EDPB guidance. I'm now seeing a lot of clients, and I'm sure it's the same for a lot of the audience, figuring out how to apply that guidance and how to make that work. I think it's too early to say how you do that in relation to distributed technology. One thing that I would make a suggestion in relation to is, I've sometimes heard the idea being posited that you might have some form of standard contractual clauses, some form of almost like inter-party agreement that you would use as a mechanism to manage these kind of data transfers. So in very simplistic terms, maybe there's a BCO, or a binding corporate rule structure that you could use for distributed technologies, because binding corporate rules, for those who are unfamiliar, is effectively a mechanism whereby on an intercompany basis, a company signs up to a set of rules approved by regulators across Europe, and that allows it to do international data transfers, irrespective of the location of the different entities. And I think that provides a very good model for international transfers generally, but it provides an especially good model for distributed technologies. The challenge with BCRs is that while they're a great mechanism, they're a great model, it does take some time to get BCRs approved. And again, I'm not being critical in any way of regulators. I understand why it would take some time. And that time has sped up. But nevertheless, that might not be ideal for technology which is moving very quickly, for applications which are developing very quickly. So that's a challenge. I think the other thing to give some further consideration to, and I think we've all done this arising from Schrems 2, is to look again at the GDPR and see, for example, do some of the derogations that exist under the transfer chapter, do they allow us, are they perhaps broader than they might have been before? And there was some interesting commentary from one of the judges involved in the Schrems 2 decision to say, like, take a look again at the derogations and see if there's anything in there. And finally, I would suggest there's always merit in considering if consent might be a workable solution here. Now, consent has a limited application in general under GDPR, and has a limited application under transfers. And I don't want to oversell this. But again, I think in circumstances where you are working with new technology, you're working with new situations where there's by its nature going to be a spread of processing across multiple locations in the globe, you do need to kind of have to look again maybe at all of your options and to see if they might be applicable.
So one thing is that we're just looking at the GDPR and the EU, but increasingly laws around the world are patterned after the GDPR with cross-border restrictions, and some countries are even going further to have some strong data localization protections. So I'm wondering, if you have to get kind of a worldwide sign off on this for the transfers, since it could kind of go anywhere, right? So I wonder how that's just practically going to work. Yeah, if we're just dealing with the EU, we're dealing worldwide.
Yeah, it's I mean it's a really it's an excellent point, Dan, to which I don't really have a very convincing answer. Which, I mean, I think that the challenge is that, you know, if you can't succeed in doing it at an EU wide level, well, then it becomes very challenging. And the challenge is always presented in my experience as being, well, how do you do transfers to the United States? I personally don't think transfers to the United States are the most challenging issue. I think there's transfers to other jurisdictions where it can be much more difficult. And if you're in a situation where what you really want to do is to be able to move the data to any location, probably if you're starting from an EU perspective, you do need to go back to something like binding corporate rules, because again, that gives you the freedom from the EU perspective to make those movements very frequently and very easily. The challenge is, though, but that doesn't solve your problem if you're moving data into locations in Asia, if you're moving data in locations in, for example, Russia, if you're moving data into locations in Africa, which is very rarely considered here. So I think you're absolutely right to point to there is a balkanization. There is absolutely a level of data localization that has increased over the last number of years. And I think at the moment, my sense is that a lot of the solutions which are sitting on top of this technology haven't really grappled with those issues. And the reason why they haven't grappled with those particular issues, particularly in relation to transfers, is that it's not that there's no solution, it's just that the solution is extremely difficult, and it's only ever going to be a partial solution as well. There's also, I think, a situation where there's a risk-based approach here. If you feel that there's going to be enforcement against you, this is an issue in which you will act, and you will be, your tendency will be to try to do something to render yourself compliant. But if your feeling is that the regulatory environment is not in a space where it's overly focused on your activity, well, then I think until you feel there's a focus, I think it's natural human nature, you're not going to necessarily act unless you feel the pressure of impending enforcement.
Well, if I may, then why don't we talk a little bit about Web3? So, Colin, when you think about Web3 built on top of blockchain, and there's many blockchains, as you know, right, at this point. Why don't you talk a little bit for viewers in the privacy community? This is where you and I live, and Dan live every day. Colin, talk about what that means. What do folks in the privacy community, how should they think about what Web 3.0 means? And then some of the privacy issues that you've seen arising out of applications or versions of Web3 built on top of blockchain.
Yeah, so I mean, look, the first thing I will say, and this is what I would say generally in relation to data protection compliance, if I was advising a client, and that is, it is a risk-based piece of legislation. Certainly the GDPR is, and I think a lot of the laws that, as Dan has referenced, which have the GDPR, let's say their inspiration or their source text, are risk-based. So you're not going to solve all of the problems. And as we've just discussed, some of the problems, I'm not saying they're unsolvable, but the solution is quite challenging and perhaps somewhat extreme. The question is trying to see what you can do, I think, within the framework that you're operating in. So, for example, if I were advising an application that was sitting on blockchain technology or distributed ledger technology, I think a key focus for me would be transparency. So I think that is an issue which is a hot button topic for a lot of regulators in Europe, including my own regulator, and I think that is something which it is relatively achievable to ensure that those who participate in the blockchain understand how their data is being used. You may not be able to explain everything about that, but you do need to explain to the extent that you can, and I think that goes some way to try to to address concerns which regulators will have about how that kind of technology will work. The other thing which I think is really important in terms of giving some degree of comfort to users, to regulators, and indeed to participants is to try to see if you can come up with some sort of contractual framework. And the reason why I say you come up with some sort of contractual framework is because I think that forces you to then try to see if you can designate the different players in terms of the roles that they play, and therefore begin to overlay that rather simplistic, but it is what we have, GDPR approach about controllers, processors, and joint controllers. Again, that's difficult to get right in a non-distributed, non-decentralized context. But I think if you can try to do that in this context, that can be really helpful as well. The last thing I would say on that point is, and again, I don't think you can do everything. For example, I think it's very difficult to, as we just discussed, to deal with the transfer issue, but it's not that difficult to deal with the security issue, right? So one of the great things about blockchain is, yes, it's an open, it's an open network, and yes, there is visibility, but there's also a lot of security possibilities and a lot of security applications available, and a lot of things you can do, particularly around encryption, particularly around putting the data effectively into a very secure context. And I think that is something I would focus on. So my top 3 takeaways, which I don't think you can do completely, but which I would focus on, would be focusing on transparency, trying to see what you can do around a contractual framework to the extent possible, and then maybe also giving some consideration to ensuring that you've done what you could in relation to those kind of frameworks. The last point I will make, sorry, which has popped into my mind there, which is something which I think is really important in the European context, is really important to do a data protection impact assessment. Now, obviously, anybody who is developing and rolling out these kind of solutions will have thought about that. But if you're bringing a blockchain solution into your business, I think that if you were able to show that you had done a data protection impact assessment, that you had identified the risks, that you had taken some steps around, for example, security to mitigate those risks, I think that would be very encouraging from a regulator's perspective in circumstances where they had cause or opportunity to discuss that particular matter with you.
So one thing about Web3, right now it's a lot of promise, and we'll see if it lives up to the hype. I often, when I hear and see discussions of Web3, it sounds like the early days of the internet, where this is going to be free and we're going to be outside of government and outside of regulation, outside of law. And of course, we saw, well, the internet wasn't outside of regulation and law, and it wasn't free, and the story was not as bright and rosy and wonderful as it was said in the 90s and early 2000s. We started to see the dark side, and that there's a lot of control. The law is kind of based on, around the fact that there is so much control on the current internet. But the promise and the hype of Web3 is that this is to be a decentralized internet, a different model where it doesn't fit into the traditional, controller data subject type of framework. So if the solutions are, let's try to map on or graft onto it some kind of a controller, it's sort of maybe defeating the purpose a little bit. That if the goal is a truly decentralized system, can this really map on? Is this really compatible at all? And is it really regulable or not? Because I just feel that there's a clash to some extent between the kind of very promise and concept of a Web3 and the model of regulation, which is built around Web 1 and Web 2.
For my part, I think that's a very balanced, reasonable statement. I mean, even the suggestions that I made in terms of things that you might think about doing, they're very much Web 1, Web 2, contextual ways of thinking. I think that the challenge you have is, if you are going to try to, I suppose, ensure that your application on this technology is compliant with current privacy law, you do need to apply that sort of Web 1, Web 2 thinking, because otherwise you won't succeed, I think. And even if you do succeed, it'll only ever be a partial success. And I think that sort of goes back to a point which I was making earlier, Dan, and I think I'd agree with you, is that in circumstances where we want this to be truly Web3, we want this to be certainly decentralized, and I think the decentralization of these kind of technologies doesn't prevent some of the problems that we've seen with sort of, for example, some of the more earlier applications of internet on the internet. I think what we need then is some engagement with regulators, and what we would need, certainly from the EU side, is a little bit of movement in terms of, for example, topics around anonymization. For example, certainly would need a little bit more flexibility on designation of roles from a data protection compliance perspective. Certainly, and this goes without saying, and way beyond Web3, there's some further thought and some further engagement needed in relation to managing international data transfers. I think that's a very obvious thing to say, but I think you are right to say. I mean, we are at a kind of a point where you do question how possible it is to apply laws which have been designed and effectively, structured with one type of internet in mind, when we have an entirely different internet emerging, which is of a very different character, both in terms of how data is used and how different parties participate in the use of that data. So I'm in full agreement with you in the sense that I would be optimistic that there is a way to find a degree of compatibility, but what I think it requires is some degree of change, both on the industry and on the regulatory side.
Yeah, I mean, you sort of wonder, will GDPR be able to flex to this new model, or how they'll accommodate it, Colin, from what you're saying? And, I think Dan and I have had many webinars in the last 2 years where neither of us believes, I don't want to speak for Dan, but unless something's changed, that there's going to be a comprehensive US law passed anytime soon in the US. But you do worry about the flexibility of a legal regime to accommodate this, when the model, at least as Web3 is sort of talked about, is so different than the model that inspired GDPR.
Yeah, I mean, I think the GDPR, is often presented as being technology neutral, and to some extent, it is technology neutral if you're talking about Web 2, right? It is absolutely technology neutral in that context. But the challenge you have is that it took from 2012 really to 2016 for the law to be developed and negotiated and agreed, and then there was a further 2-year lead-in period. So you're talking about like 6 years before you even have a law which was being prepared and negotiated taking effect. And then we're 4 years out from that. So it's not surprising, I think, that the technology has moved on very quickly and that the law is struggling to a certain extent to keep up with that. But in my experience, that's always been a problem in technology law. It's always a situation where, you have a new regulation emerge and very quickly that regulation looks out of date. Again, I mean, at an EU level, we had a proposal last year for, a regulation to do with artificial intelligence. My sense is that once that regulation is finalized, which hopefully will be sometime this year, and it emerges very quickly, it's going to look a little bit creaky around the edges. It's going to look a little bit dusty. And it's going to look a little bit like its old hat. So it is a constant problem. I think that the issue on the GDPR side is really the GDPR's basic fundamental structures do work on the assumption that there is a centralized model, that there is one or two parties who enjoy a large degree of responsibility or assume a large degree of responsibility, whereas this model really is working from a completely different perspective.
And I think one of the things, though, that needs to be thought is, every law, I mean, ultimately the GDPR is structured in a way to achieve a goal. And I think the big goal that a lot of the laws are trying to do is power, right? If you really say, what's the point of all this? What's the larger purpose to all of these rules? They're not for their own sake, but they're for a larger goal. And that goal is, addressing power, making sure that the controller doesn't have too much unfettered power, that the processor doesn't have too much unfettered power, that there's accountability to the data subject, and the data subject's protected, and the data subject is not totally powerless. Once we shift to this decentralized internet, if we do, when we look at that model, I think then the question is, who has the power? I'm very skeptical of the kind of, Pollyanna-ish talk of, oh, it's going to be beautiful and lovely, and the lion will lie down with the lamb in Web3. I think there will generally be some entities that get power in the new system, find a way to exert power, and it always happens every time, no matter how optimistic it might be, someone gets power. And I think ultimately the law needs to put the regulation based on that. I think one of the problems is we really don't know that yet. we don't know what that's going to look like, and who the powerful are going to be in this regime. So it's not clear where the law can go. We could try to retrofit the GDPR, but that's not clear that it's going to put the pressure on the right power wielding entities. And I think that that's for someone like regulators thinking about where to go next, I think should think a little bit about those bigger questions. Retrofitting the GDPR, I think, will look silly if it's pushing on the wrong entities that don't have power and missing the entities that do. We just don't know yet. So I guess in the short term, how do you square this with the GDPR? In the long term, how we regulate this really, I think, depends on that big meta question.
Absolutely, and I think what we probably see, certainly from an EU perspective, is that there will be no sudden movements. I mean, we haven't really had any big enterprises emerge yet who are really trading off this kind of technology. I think we are in an early stage. There's a lot of promise, and there's a lot of, some of them are very rosy promises which are being made, but we have yet to see that. I think a little bit like, and we can debate the success or otherwise of how the GDPR kind of reacted to the emergence of big tech in particular. I think what we will probably see is once the power, and I think you're absolutely right, the power will manifest itself in some way. It'll center on, even in a decentralized context, it'll center on one or two particular entities. I think then you will see a response in relation to the law will respond. The problem is, I think it's too early to do that. Because those companies don't exist. I think secondly, you're absolutely right, retrofitting existing legislation at this point in time doesn't seem to me to be the right thing to do. However, the challenge is you will have that, I suppose, lacuna, you'll have that gap in circumstances where you will see these technologies emerge, you will see them become more common, you will see the application become more frequently used, but you will have a regulatory framework which really will struggle to apply to those kind of regimes.
Yeah, look, Colin, first of all, I know we're hitting the end of our time. This has been a terrific discussion, and I hope you'll rejoin us when Dan and I pick up more on this subject. There's going to be a lot. This is very early days, in my view, on a lot of the subjects we covered. And my key takeaways are, right now, if you just applied a law, and many laws that are built for Web 2, and you try to apply it to a blockchain concept or what's being talked about as Web 3, there's some tensions. And I think the three big ones that I would look at are the concept of individual rights, the concept of who exactly is in charge of the data, who's the controller, who's the processor, and how do you think about the concept of distribution of data and international data transfers with something that's a fundamentally distributed architecture? Very different even than cloud. Cloud, you at least know where your resources are. You don't really know where your database is distributed in a blockchain infrastructure. And then to summarize, I shared Dan's view that I think if you're a regulator, you probably have to look with a somewhat jaundiced eye or with a lot of concern about the concept that it's going to be self-governed entities that are democratically based with no intervening entity. I think fundamentally you're already seeing some very significant funds, like venture capital funds, that are investing in some of the major currencies and some of the major technologies, with the effect that they own a huge chunk, like one or two or three major investors effectively own the currency or the underlying voting power in some of the major emerging cryptocurrencies. And if the cryptocurrencies become the underlying pinning of, a distributed architecture, then you get to Dan's point, it may not be functionally independent in the way that people think. So I think we're going to have to watch this area very carefully. But on the other hand, it is exciting to see what you might do in this Web3 world. in a way that would free from, 5 platforms kind of controlling a lot of our daily activity. There is at least a potential that we move from one kind of challenge, which is the major platforms, to a different one. And I think Dan's right to highlight that potential. But anyway, I know we've hit the end of our time. I just want to, on behalf of Dan, before I turn it over to him, I want to thank you. I hope you'll come back and join us again. And I'm looking forward to seeing where this goes from your perspective, Colin.
Okay, well, thank you very much for the invitation. It was great to be invited to speak, and a very interesting topic. So thanks very much.
Thanks so much for joining us. I think these are really fascinating questions, and it's definitely something I think we'll continue to talk about in the future, both in terms of the legal implications of all this, to think just generally where things are headed, what is going to happen with Web3. I just know historically, someone always is in control. Someone always finds a way to exercise more power over others. So there will be, I think, we just don't know who or how yet, but there will be that. Someone exercising control in these systems.
Mm-hmm.
How that shapes out, we will have to wait to the future, but certainly have our hands full looking at the models that existing regulation, how they work, and then ultimately what we built this regulation very much for how the world works today. But as always, the minute we kind of get that right, hey, there's something new. Anyway, that means continued conversations. Thanks so much for joining us. Thanks, Justin, for this, and have a great afternoon, everyone.
Yep. See you soon. Thanks, Colin.
Yes, guys. Thank you.